separation of powers principle in the Florida Constitution permits section 51.011 subsection 2 to condition issuance of discovery on a represented party on a court order where the rules of civil procedure 1340 and 1350 expressly state that such an order is not a precondition to issuance of discovery. Second issue is whether the trial court could release rent funds in a summary procedure case. And third, whether denying intervention and jury trial violated our constitutional rights. I understand there's probably some concerns about preservation. So I'll just go through the issues and respond to your questions, of course. So starting with the discovery, the appellee contends that it's not preserved because we raised it. Well, we raised it in our answer, but we also raised it in our motion to strike the response to the motion to compel. Importantly, in the judge's order, it's in the record at 261, the judge did indicate that she read that motion to strike and relied on it in making her decision. So I would contend that.
Let me ask you this, though. You didn't attend the final hearing. Plural, really, I suppose.
Yes, sir.
And how do we know you were harmed? If this was error by the judge, how do we know that you were harmed by not being able to do the discovery you wanted?
Thank you for that question.
We don't see any of the evidence that was presented. We don't see any of the issues that were raised at the final hearing.
Well, the first point I would make about that is it's not she didn't really make a discretionary ruling. It's a blanket denial of discovery.
Yeah, but how were you hurt?
How was I hurt? Okay, so I think it would help to go back and sort of rehash what happened here. The complaint was filed on October 25th. On November 7th, we timely answered, issued the discovery and filed a motion to determine rent. And then on the 22nd, the appellee noticed our motion to determine rent without conferral and without responding to the discovery. And so we go forward. I moved to strike the notice based on those concerns. The court denies the motion to strike at 5 p.m. the day before the hearing. And then at that hearing, she makes findings that no abatement has been shown, no right to an abatement has been shown. So that's as far as I can take it in terms of showing harm, or I mean, it's a structural error. I think it's the prejudice.
No, it's structural, but go ahead and in the sense that you can escape preservation or show that we suffered a harmful error. But
yes, sir. In addition to that, the fact that she made findings without the discovery that I couldn't show that there was any right to an abatement, any arguable right to an abatement. That's as far as I can take it.
You have testified.
What's that? I'm sorry.
You can testify.
Yes, sir.
Your wife can testify.
Yep, I offered my self-serving testimony, and that was so. At that point, it was just me. My wife hadn't come to the apartment at that time yet. She was in Spain, and this is all in the record that she came later. That's why she was not able to provide any testimony, and we just moved in, so I didn't know anybody in the neighborhood, etc. So I was forced with having to offer the same self-serving testimony that she had already rejected. And under those circumstances, I didn't see any point in attending any further hearings. In addition to that, we had demanded jury trial, and that demand remained unstricken all throughout the course of the proceedings. So that's another reason why I did not attend. It could have been viewed as consent if I showed up. They'd certainly be here arguing that I consented to a non-jury trial, and I consented to all the things that led up to the final.
You could show up and say, I renew my objection to the non-jury trial.
Yes, sir. I suppose I could have.
So the hearing went forward on January 8th, is that right? 2020?
Yes, sir.
You were not there, right?
That's correct.
Transcript of it, what was said, what happened.
Yes, so I think you're bringing out Applegate, and I don't think Applegate bars review here.
Yeah, just asking.
Oh, yeah, my understanding is that there's no transcript.
Right.
That's my understanding, yes, sir. But again, we don't dispute the facts. The facts are not necessarily in dispute. These are all procedural legal issues don't require a transcript that appear on the face of the record. With the money release, there is a more serious problem with preservation. Of course, in our answer, we did raise insufficiency of process and failure to state a cause of action because they did not seek the unpaid rent in the complaint. And furthermore, once the order came down to deposit, we did file a motion to vacate, and it was based on personal jurisdiction grounds, which is problematic. I would have to concede. But even still, I think that the discovery issue moots this point altogether. And if it doesn't, I would still ask you to reach this issue on fundamental error grounds. And as to the merits, if I may briefly go through the merits, I think it's pretty straightforward on these two issues. The text of section 51.011 subsection 2 cannot be reconciled with the language of rules 1340 and 1350. All the cases relied on by the appellee for this issue just generally discussed the summary procedure statute. For example, they cite as on point this case called Crocker that dealt with subsection 1 and the time frame in which a defendant must answer the complaint. The rule at issue in that was 1140, which the first words of 1140 are unless provided by statute. So that's in stark contrast to the rules at issue in this case, which is 1340 and 1350, that explicitly say that a court order is not required. As to the merits of the money release, I rely heavily on Amiri, which squarely held that unpaid rent is not recoverable in summary procedure.
Yeah, but I think, is there a distinction between the rent that is tendered into the registry of court and therefore is paid, not paid over to the landlord at that time, but is paid by the tenant in order to remain in it, and damages for breach of the lease?
Yeah, that's a good question, Judge Northcutt. I don't think so, because if you don't pay the rent, the money into the registry is ordered, you're going to be evicted. But that being said,
The rent is paid. The rent has been tendered. It's just not tendered directly to the landlord. It's been tendered into the registry of the court.
Yeah, but there's still that dispute about what constitutes the rent, especially under these facts where we weren't able to get discovery. We had a Zoom hearing that was non-evidentiary in nature, and all those issues with how the court came to the conclusion that the rent was the specific number. And by the way, the court's order that we deposit $490 more than allegedly owed in the complaint. So, and also on the money release, the notice of the final hearing did not mention anything about the money release. So not only do you not have a pled relief, you also don't have notice in the notice of the hearing. Sorry, I would reserve 5 minutes. I promised myself I wouldn't do that.
I've got it written down.
Thank you, sir. So I'm going to move on from those two issues. I think that those are really strong issues. But obviously I welcome any questions. Moving to the jury, we get a little bit closer to trying to dispute facts here, but I would just rely on the fact that we had a demand. Obviously, the presumption is we still have jury trial in the state of Florida. That demand must be stricken. I mean, the attorney below just couldn't be bothered. He didn't object while I'm on that topic. He didn't object to the discovery timely within 30 days. So that's another basis to find waiver. So that same issue applied here with the jury trial. And the appellee is going to contend that, we had this contract that it had a jury waiver. And in response to that, I would just point out the details of that contract or that lease, which was given to me after I already made a deposit in earnest money, almost $300, I believe is in the record. It's a 59-page contract with legal size pages that needed to be specially print. We have uniquely good evidence of the process that was followed in signing the lease because they used a proctoring software that showed 28 signatures in 10 minutes. And there was obviously no opportunity to suggest an alternative term or modify any of the provisions. Unless there's questions, I will reserve the rest of my time. Thank you.
Thank you.
May it please the court. I'm Ginger Boyd of Nelson Mullins on behalf of the appellee, West Park Village Owner LLC. As the court is aware, the underlying case is a very straightforward residential eviction for non-payment of rent. While the appellant is asking this court to reverse the final judgment that was entered, the appellant's not attacking the merits of the judgment and he's not attacking the merits of the orders that were entered. Instead, he's making ancillary attacks on related to the process that was employed by the trial court in reaching its decisions. And the asserted errors in the process are simply not well-founded and are not preserved below. Let's talk about the summary procedure briefly with regard to constitutionality. Appellant has asserted that the summary procedure is unconstitutional. He's not cited any case law that supports his position, and he roundly ignores all of the case law that's been cited with regard to this particular issue, to the extent that the Florida Supreme Court has addressed the constitutionality and has said specifically that unless the court overrules by rule what the statute has indicated, then the statute is applicable. This statute, the summary procedure statute, is an old statute, and there's just simply not a basis for this court to find that it's unconstitutional, and they haven't established a basis that it's unconstitutional. With regard to the discovery issue that is a part of that discussion, what the appellant fails to recognize is that there was no harm to him, as the court has pointed out, because there were other ways for him to get the discovery he's claiming he needed. If he wanted information about the name of the plumber, he could have taken a deposition of the management company. That was allowed for purposes of discovery under the statute without approval of the court. He did not avail himself of that opportunity, and the record shows no evidence that he attempted to set a deposition prior to the rent abatement hearing to the extent he felt like that information was necessary for him to present at the rent abatement hearing. He didn't do that. To the extent he complains about the rent abatement hearing and the amount of the amount of money that the court indicated needed to be paid into the court registry, there's no indication in the record below that he ever asked the court to reconsider their order. He didn't file a motion to correct the amount of the order or the rent that was ordered to be paid into the court registry. He also at no point asked the court to reconsider those amounts, either before the final judgment was entered or after the final judgment was entered. Now, he indicates that there was no point in attending any of the hearings, but what he fails to understand with regard to due process and with regard to preserving issues for appeal is that you have to show up for the hearings to create a record. He simply didn't do that. The point of showing up at the hearing, if he thought he had a meritorious issue, was to create a record so that he could then present that issue to this court with an appropriate record and preserving those issues for appeal. That simply did not happen in this particular case. With regard to the amount of the rent that he asserts, or the issue with regard to the rent being released to the landlord after the final judgment, he's misreading the Amiri case. The Amiri case indicates that, I understand that Judge Atkinson wrote the opinion, but as I understand the holding in that case, what the court was indicating is that the landlord could invoke the summary procedure for eviction, and then later could bring a damages action if it chose to do so. That was the holding in that case. And that's not the issue here.
It could not have brought the damages action in the summary procedure.
Correct. Because and the issue
Which is why it wasn't res judicata.
Correct. And the issue there, as the court notes, is that there were two separate proceedings going on. The argument was the damages action should have been brought as a compulsory counterclaim or as a compulsory claim in the summary procedure. And the court said that you can't do that under the summary procedure, so you would have to have a separate action. So that case is really not applicable. It's distinguishable from the cases before this particular court. And as the court's already noted, what was released from the court registry were not damages, but the rent that was required to be paid to protect the interest of the landlord. That rent is essentially functions the same way that a bond would function to prevent the harm to the landlord by not having the use of his premises and not being able to lease that premises to a third party while the eviction action is proceeding. So with that, unless the court has any questions regarding the issues, we would stand on our briefing and we would ask the court to affirm the judgment in this case. Thank you.
Just very briefly, this is in the briefs, but in 1978, the Florida Supreme Court did reclaim its procedural territory with respect to discovery propounded to represented parties. So the idea that, these cases are all applicable, and that's the stated rule in Crocker. It says if the Florida Supreme Court finds a statutory special procedure that it disagrees with, it will say so. And here it clearly has in 1978 with respect to the 1967 summary procedure statute. Ultimately, well, first, as far as the adequate substitute of depositions, I would say that's not an adequate substitute. We did have a switch in the property management company, as evidenced by the 3-day notices issued by two separate property management companies. Very confusing situation. Attempts to contact counsel were ignored. This is indicated at record 65. So that was not an adequate substitute to take the depositions. Ultimately, you can't have your cake and eat it too. Once the deposit is made, there's no interest. The public policy protecting the landlord from holdover tenant during litigation, that's totally reasonable. That's within the power of the legislature to do that. But once the money is deposited in the registry, that interest evaporates, and due process should be afforded to litigants under those circumstances. I would ask the court to reverse and remand with instructions to order the money returned to the registry and either dismiss the case as moot or conduct further proceedings consistent with the Florida Rules of Civil Procedure and the Florida Constitution. Thank you.
You got it. Yeah, sure.